Hi, I'm Jerry Sparks, President of AG Financial Insurance Solutions, and welcome to Risk Management Live. Once again, we have with us Rich Hammar, renowned attorney for the Assemblies of God, and just an expert in regards to risk management, renowned author, and we're just so glad to have you. And with this subject here, we're going to be talking about talking about gay marriage and employment discrimination in regards to sexual orientation. You can tell that we're not shy about staying away from the hard subjects. So getting into that, why don't you start with gay marriage?
Okay, well, Jerry, I received so many inquiries in recent years over this whole issue of gay marriage from pastors, from churches that are asking me, you know, can I go to jail if I refuse to perform a marriage between people of the same gender? Or what if my church refuses to allow them, a same-sex couple, to be married in our church? There's a lot of paranoia, I think, over this issue today. And I think it's important to recognize at the outset that people's views on these issues are very polarized. And I mean, that goes without saying, that a lot of people, a lot of religious people, a lot of churches, a lot of clergy in this country feel that people should be treated the same, equally, regardless of sexual orientation. And that, a lot of things flow from that, you know, that same-sex couples should be permitted to marry, and there should be no discrimination by private employers against people because of their sexual orientation. And so that's kind of one side of the spectrum. In fact, a number of churches and denominations in this country ordain clergy who are homosexual. Some try to limit it to non-practicing homosexuals. Some don't care. So that's one side of the political spectrum. On the other side of the spectrum, or may I say theological spectrum, you have many, many churches, clergy, church members who are just as adamant that homosexuality is a unique status, and because it's denounced and condemned in the Bible in unequivocal terms, and the definition of marriage is unequivocal in the Bible, and therefore clergy and churches should not be hosting or performing marriage ceremonies between people of the same gender. And churches should be free to discriminate in employment decisions on the basis of sexual orientation. So you have this diametrically opposed views with regard to these issues, and that makes it very controversial. As you said, we're not ducking the hard questions here in Risk Management Live. So let's talk about that first issue of gay marriage, and then I'll follow up by talking about employment discrimination in general. I think it's interesting to note at the outset that there are 12 states currently that have recognized same-sex marriage. In some of these states, it hasn't taken effect yet, but in 12 states, plus the District of Columbia, same-sex marriage either is legally countenanced or it soon will be. Those states are Connecticut, Delaware, Iowa, Maine, Maryland, Massachusetts, Minnesota, New Hampshire, New York, Rhode Island, Vermont, and Washington. On the other side of the divide, you have 6 states that have enacted legislation that defines marriage as a union between a man and a woman, prohibits same-sex marriage in 6 states. In 30 states, the voters have enacted constitutional amendments to the state constitution defining marriage as a union between a man and a woman, implicitly rejecting same-sex marriage. That's not by statute, but by amendment to the state constitution. So, in those states, a state court could not say that such a law violates the Constitution because it's in the Constitution. So that's what makes, I think, a constitutional amendment at the state level more effective than a statute, which any judge can say violates the state constitution or even in some cases federal. And as we'll see later, the United States Supreme Court is going to weigh in on this issue here probably within a few months. And if they make a ruling based on the federal Constitution, such as the Equal Protection Clause of the Fifth Amendment, if that is violated by state laws that prohibit same-sex marriage, then all of these 30 state constitutional amendments go up in smoke instantly, plus, of course, the statutes. So it remains to be seen. We'll come back to that topic here in a few minutes. I also want to mention the Federal Defense of Marriage Act, which was enacted by Congress back in 1996, which basically states that for federal purposes, in terms of federal law, marriage is defined as a union between a man and woman. 8 federal courts have ruled that that statute is unconstitutional. 5 of those are being appealed to the United States Supreme Court. And again, in this term, they should be rendering an issue on that issue, as well as the legality of same-sex marriage in general. The state of California, I didn't mention in our listing of 12 states plus D.C., because California is a unique state. In 2008, the California Supreme Court ruled that same-sex marriage is constitutionally mandated and certainly permissible in that state, that any attempt to the contrary would violate the state constitution. That was reversed by a public referendum known as Proposition 8 in about 2010. And so then the Proposition 8 was itself challenged, and a federal court in San Francisco, a federal judge, ruled that Proposition 8 was unconstitutional. Boy, whoever decides what's constitutional or not has a lot of authority in this country, obviously. And because you have these vitriolic divide, they're so polar opposites here. Everybody trying to interpret what the Constitution means. And so that Proposition 8 was deemed to be unconstitutional by a federal district judge in San Francisco. That was appealed to the Ninth Circuit U.S. Court of Appeals. And that court last year ruled that, agreed with the federal district court in San Francisco that Proposition 8 was in fact unconstitutional. So now this case has been appealed to the United States Supreme Court. And oral arguments were held in March. Of course, it's hard to divine what the justices are thinking, but some court watchers have surmised that possibly there were indications that several of the justices were maybe looking for a way out, a backdoor exit from this controversy, for them to duck the issue on making a nationally binding precedent here and pretty much kicking it back to the states to decide how they want to do. A lot of people have condemned the abortion ruling in Roe v. Wade back in 1973 because it took the issue away from the democratic process and it became a fiat or a dictate by 6 out of 9 Supreme Court judges. And as a result, we've had 40 years of social unrest in this country. And because I think a lot of people believe the voice of the people was ignored. You don't see that in many European countries where abortion rights have been advanced through legislation and more democratic processes. So I think the U.S. Supreme Court has, and I've seen some speeches by some of the current justices that kind of make me believe that that's the case, that there's a certain sensitivity to this argument, and that maybe it might be better for volatile issues of social policy, which are so, they cause such a difference of opinion, hostile difference of opinion, that perhaps those social issues should be best resolved by the electorate, meaning at the state level. So we'll see what they do. At this point, believe me, there's no way of knowing what the court is going to do. But the bottom line is, sometime this summer, probably, the U.S. Supreme Court will weigh in on this issue one way or another, and I'll return to this issue later. But what we do know now is that 4 state Supreme Courts have found same-sex marriages to be constitutionally mandated certainly under state constitutions. I want to read to you excerpts from these opinions. These opinions, by the way, are well over 100 pages long each, and I've carved out just about 50 pages I'd like to read to you. No, I've carved out the essence of these rulings And so listen to this. Here's the California Supreme Court ruling in 2008 that was overturned by Proposition 8, which itself was overturned by a federal district court and the Ninth Circuit Court of Appeals. Here's what the California Supreme Court said. Affording same-sex couples the opportunity to obtain the designation of marriage will not impinge upon the religious freedom of any religious organization, official, or any other person. No religion will be required to change its religious policies or practices with regard to same-sex couples. No religious official will be required to solemnize a marriage in contravention of his or her religious beliefs. What is the translation? Clergy are not required, even if same-sex marriage is deemed to be constitutionally mandated, clergy cannot be liable for following their religious sensibilities and not choosing to participate. So, and then how about this? The Connecticut Supreme Court in 2008, at about the same time as that California ruling, said this: religious freedom will not be jeopardized by the marriage of same-sex couples because religious organizations that oppose same-sex marriage as irreconcilable with their beliefs will not be required to perform these marriages or otherwise to condone same-sex marriage or relations. However, because marriage is a state-sanctioned and state-regulated institution, religious objections to same-sex marriage cannot play a role in our determination of whether constitutional principles of equal protection mandate same-sex marriage. Again, clergy are not required to participate in these ceremonies, and churches are not. How about the Iowa Supreme Court in 2009? In the final analysis, we give respect to the views of all Iowans on the issue of same-sex marriage, religious or otherwise, by giving respect to our constitutional principles. These principles require that the state recognize both opposite-sex and same-sex civil marriage. Religious doctrine and views contrary to this principle of law are unaffected, and people can continue to associate with the religion that best reflects their views. A religious denomination can still define a marriage as a union between a man and a woman. And a marriage ceremony performed by a minister, priest, rabbi, or other person ordained or designated as a leader of the person's religious faith does not lose its meaning as a sacrament or other religious institution. The sanctity of all religious marriages celebrated in the future will have the same meaning as those celebrated in the past. The only difference is civil marriage will now take on a new meaning that reflects a more complete understanding of equal protection of the law. This result is what our Constitution demands. And then finally, the Massachusetts Supreme Court, which is the first state Supreme Court to address this issue back in 2003, over 10 years ago, said this: our decision in no way limits the rights of individuals to refuse to marry persons of the same sex for religious or other reasons. It in no way limits the personal freedom to disapprove of or to encourage others to disapprove of same-sex marriage. Our concern, rather, is whether historical, cultural, religious, or other reasons permit the state to impose limits on personal beliefs concerning whom a person should marry. So those are state court rulings. That the only state Supreme Court rulings, the four that I just quoted from, each one of which articulates the view that even though those courts were recognizing same-sex marriage as constitutionally mandated, it didn't mean that clergy were required to perform them contrary to their religious views, or that churches were required to host them contrary to their religious views. No court has said to the contrary. Now, what about the federal courts? Well, remember that Ninth Circuit Court of Appeals that affirmed the San Francisco District Court ruling in which Proposition 8 was found to be unconstitutional, said this is 2012. Marriage in the United States has always been a civil matter. Civil authorities may permit religious leaders to solemnize marriages, but not to determine who may enter or leave a civil marriage. Religious leaders may determine independently whether to recognize a civil marriage or divorce, but that recognition or lack thereof has no effect on the relationship under state law. Proposition 8 does not affect the First Amendment rights of those opposed to marriage for same-sex couples. Prior to Proposition 8, no religious group was required to recognize marriages for same-sex couples. Affording same-sex couples the opportunity to obtain the designation of marriage will not impinge upon the religious freedom of any religious organization, official, or other person. No religion will be required to change its religious policies or practices with regard to same-sex couples, and no religious official will be required to solemnize a marriage in contravention of his or her religious beliefs. So I think the interesting thing to note about this federal appeals court ruling I just quoted from last year, and by the way, this is the case that's now been appealed to the United States Supreme Court, and it will be resolving this issue as an appeal from this Ninth Circuit case I just quoted from. The interesting thing is the Ninth Circuit Court of Appeals based its ruling on the constitutionality of same-sex marriage and the invalidity of Proposition 8 was that it violated the Equal Protection Clause of the United States Constitution. Now, that trumps all state laws. It trumps all state constitutional provisions. So you remember I said 30 state constitutions define marriage as a union between a male and a female and reject same-sex marriage. In one stroke of the pen, literally, this summer, the Supreme Court, all it has to do is agree with the Ninth Circuit Court of Appeals and say this is a matter of federal constitutional jurisprudence, that the federal constitutional guarantee of equal protection of the laws mandates that same-sex couples be given the same right to marry as heterosexual couples. If that's the case, then all 30 of these state constitutional provisions, all 6 of the state statutes are per se rendered unconstitutional in a single ruling. So we'll just have to wait and see. But I want you to understand that even if that happens, it doesn't mean that that clergy are going to be exposed to any liability, be that civil or criminal, for following their conscience and their religious tradition and beliefs. Those who choose not to perform these marriages are not going to be penalized for that. And churches that are theologically opposed to these marriages are not going to be liable for failing to host them. And then let me also mention this. The United States Supreme Court, in a series of cases, including the Kedroff case back in 1952, has given such broad expression to the freedom of religious organizations to operate without governmental intervention. Here's what the court said in one of these cases. Our prior decisions radiate a spirit of freedom for religious organizations, independence from secular control or manipulation, in short, power to decide for themselves, free from state interference, matters of church government as well as those of faith and doctrine. These are the kinds of cases that are going to be cited and raised before the court and have been in briefs right now in the same-sex marriage case. So that's why I believe that the Supreme Court, if it doesn't duck the issue on a technicality, is going to do what all these other courts have done, without exception, and give a broad expression to the religious freedom of both churches and clergy to marry or not marry based on their religious convictions. There's 3 conclusions I want to draw here with regard to this first issue of same-sex marriage. 3 things. Number 1, no minister is required to perform a same-sex or any other marriage contrary to his or her religious beliefs, period. Anything you've heard to the contrary is false. Number 2, no church is required to allow its facilities to be used for same-sex marriages in violation of its religious beliefs. There's a lot of confusion on these 2 points, but what I'm trying to do is present a rational view based on the legal precedent of where churches and clergy stand on these issues. And number 3, and here's a hot issue, do you need to change your bylaws to prohibit same-sex marriage? I don't think so, not at this point. Maybe in the future, depending on what the courts start ruling, that may be necessary. But now I just don't see that it's necessary because of the broad expressions of religious freedom that have been given by every court that's addressed the issue of same-sex marriage. It's inconceivable to me in this environment that, that such a provision is going to be necessary for you to have such freedom. Let me give this analogy. I think you're all opposed to incestuous marriage. Well, have you changed your bylaws to prohibit marriages between a brother and sister or between a parent and child? That's incestuous. Well, no, we haven't done that. Well, why not? That's clearly prohibited in the Bible. Or what about, you know, you don't marry 10-year-olds? Do you have that in your Constitution? Why not? Or what about marrying those unequally yoked? People from different faith traditions, or maybe no faith whatsoever. My wife, when we started dating, I was an atheist. And I'm just thankful that, that she didn't rule me out and reject me as a boyfriend. And it was through her wonderful, godly life and example that I was brought into the family of God and brought into a recognition of Jesus Christ as the Savior of the world. And my life was changed forever because of it. So I thank God, Jerry, that my wife, I'm not going to date this guy. This guy. But some people believe strongly, and there's scriptural evidence for this, precedent for this, that people unequally yoked, as Paul says, perhaps should not marry. And so there's a number of, what about polygamy? Have you changed your Constitution to say that? We're not going to let one man marry 10 women, or vice versa. Why isn't that in there? Well, the point is, there's a number of marriages. Are you going to be sued if a polygamous, if a man says to pastor, I want to marry 3 women, and you say, well, I'm not going to participate in that ceremony. Oh, you're going to go to jail. No, we never even think about that, because pastors have the right to decide who they're, well, I have 2 10-year-olds, they're in 4th grade, they want to get married. My daughter, when she was in 7th grade, she already had 12 proposals. One of them she broke up with, and she said, he just called me, Dad. He's sitting out in the front yard in the rain, praying that lightning will strike him, because I, what drama amongst 12-year-olds. So, well, what if they wanted to get married? Well, you're not going to marry those people. Why? Is that in your bylaws? So you see what I mean? A lot of stuff we don't. The bylaws isn't the place. The bylaws is a document containing rules of administration and governance, not your policies. That should be in a different document, such as a policy manual. I don't think it needs to be there. If you want to put it there, you go ahead. But again, where are you going to draw the line when it comes to some of these issues? You don't need to do it at this point with regard to any of these. Polygamy, incestuous relationships, marriage between children, and on it goes.